Welcome back to Verdict Watch. Today we're explaining one of the most closely watched technology lawsuits of 2025, Bartz versus Anthropic. This case pitted best-selling authors against the AI company Anthropic, creator of the Claude AI chatbot. The core allegation? That Anthropic illegally used millions of copyrighted books to train its AI models. At stake were not just billions of dollars, but also the future relationship between artificial intelligence and creative industries. In this video, we'll walk step by step through the origins of the case, the arguments on both sides, the landmark fair use ruling, the surprise settlement, and what it means for authors and AI worldwide. The lawsuit was filed in late 2024 by authors Andrea Bartz, Charles Graeber, and Kirk Wallace Johnson. These authors claimed Anthropic had secretly downloaded books, including their own bestsellers, from piracy websites known as shadow libraries, such as LibGen and ZLibrary. The allegation was simple but powerful, that their intellectual property was taken without permission or payment, then used to build and improve Claude AI. For writers, their books are years of hard work, research, and creativity. To see them scraped and repurposed for free felt like both a violation of their rights and a threat to their livelihoods. The Authors Guild quickly supported the plaintiffs, making this a class action case representing many more writers. Anthropic, on the other hand, argued that AI models function very differently than piracy. The company compared AI training to a student reading thousands of books in a library to learn how to write. They insisted Claude AI doesn't store or reproduce books word for word, but instead learns patterns in language. Anthropic maintained that using written works to train an algorithm is transformative, and therefore falls under the U.S. legal principle of fair use. This defense was crucial, because if AI training on books was deemed illegal, the entire AI industry, from Anthropic to OpenAI and Google, could face massive legal barriers. In June 2025, Judge William Alsup delivered an important early ruling. He stated that using legally obtained books to train an AI model does qualify as fair use. He compared it to a human writer who reads and studies many books before creating their own original work. However, he drew a line at pirated books. The court made it clear that downloading millions of works from illegal sources like shadow libraries does not enjoy the same protection. That left Anthropic facing trial specifically on the piracy issue, and the stakes couldn't be higher. Millions of works were allegedly scraped and stored. Evidence presented in court revealed Anthropic had downloaded over 7 million books through shadow libraries. Imagine the scale. Nearly every genre, from novels to biographies to textbooks. U.S. copyright law allows damages ranging from $750 to $150,000 per work infringed. If multiplied by millions of works, Anthropic theoretically faced exposure in the trillions of dollars. While such astronomical damages were unlikely to ever be awarded, even a fraction of that liability could have bankrupted the company. This created immense pressure to find a resolution outside of trial. Both authors and Anthropic knew a negotiated deal might be better than a courtroom showdown. For authors, this case wasn't just about money. It was about dignity and recognition. Writers often struggle to make a living from their craft. To see their work copied into a massive AI system without permission felt like a theft of creative labor. Many feared that AI tools trained on their words would eventually compete against them in the publishing market. The Authors Guild called this lawsuit a fight to secure respect for human creators in the age of machines. For many in the creative community, this trial was about setting a boundary, saying that innovation cannot come at the expense of authors' rights. From Anthropic's side, executives stressed that AI research benefits everyone, from education to accessibility to productivity. They warned that overly strict rules could halt innovation and give an advantage to countries with looser copyright enforcement. Anthropic's lawyers highlighted that Claude AI is designed with safety and ethics at its core, positioning the company as a responsible actor in the AI race. The company did not deny that shadow library data was used, but they argued this was an industry-wide practice. In their view, singling out Anthropic would unfairly punish one company, while others quietly did the same. Then came the surprise twist. In late August 2025, just months before trial, Anthropic announced a proposed class action settlement with the authors. The terms remained confidential, but representatives for the writers called it historic. The deal avoided what could have been a billion-dollar legal battle in court. While settlements don't create binding precedent, this agreement was widely seen as a turning point. It showed that AI companies may prefer compromise over risking unpredictable jury decisions and potentially devastating damages. The timing was key. Anthropic settled right after securing billions in fresh funding, meaning the company had both the resources and the incentive to close the case quickly. The writing community largely celebrated the news. The Authors Guild expressed hope that this settlement sends a message to AI developers everywhere. Creative work cannot simply be taken without consent. Many authors felt relieved, believing the case forced AI companies to respect the law and negotiate fairly. But not everyone was satisfied. Some writers wished for stronger, court-established rules rather than a private settlement. Still, the consensus was that this was at least a step in the right direction, proving that authors' voices were being heard in the rapidly changing world of artificial intelligence. Beyond authors, the tech and publishing industries paid close attention. Competing AI firms quietly studied the outcome, knowing their own legal battles could be next. Some publishers felt empowered, believing they too could demand compensation for AI training. Meanwhile, policymakers in Washington and Brussels pointed to the case as evidence that copyright laws need urgent modernization. Even Anthropic's rivals, like OpenAI and Google, knew this case could reshape the economics of AI development. If settlements become the norm, licensing deals between publishers and AI companies may soon be standard. The settlement didn't end the copyright debate, but it certainly changed the game. For creators everywhere, this lawsuit is a wake-up call. Whether you're an author, a musician, or a digital artist, your work might already be inside someone's AI training dataset. The Bartz vs. Anthropic case shows the importance of copyright registration and collective action. It proves that creators can organize, challenge powerful tech firms, and win recognition. While the exact compensation remains private, this case empowers artists to demand a seat at the table as the AI revolution unfolds. Protecting creativity in the digital era is becoming just as vital as producing it. In conclusion, Bartz vs. Anthropic was more than just a lawsuit. It was a battle over the future of intellectual property in the age of AI. The court affirmed fair use when works are lawfully obtained, but drew a firm line against piracy. The settlement shows that compromise is possible, but also highlights the urgent need for clearer laws and ethical guidelines. For authors, it's a victory that their voices cannot be ignored. For AI companies, it's a warning that innovation must balance with responsibility. This is Verdict Watch, bringing you in-depth analysis of the world's most important legal issues. Until next time, stay informed.